Good morning and welcome to the Employment Law Update. This is our last Employment Law Update for the year 2023, but as usual, we're not short of important cases impacting the employment law landscape in South Africa to share with you. My name is Lusanda Raphulu. I'll be facilitating this morning's update. I'm joined by my colleagues in our employment and benefits practice, whom I'll introduce as we get to the cases that each of them will be presenting. If you're a regular attendee of our Employment Law Update, most of them will be familiar faces. Before we begin, I would like to run through a few housekeeping matters. As participants, you are automatically muted and the chat functionality has been disabled. So should you have any questions during the webinar, please make use of the Q&A tab at the bottom of your screen. Your questions will be submitted to me, and I will select a few to discuss at an appropriate point during the webinar. Please note, we will not be providing written answers to questions. This webinar is being recorded, and a copy will be made available on our website at www.bowmanslaw.com. In addition, we'll be sending you a high-level summary of the cases that are discussed this morning with key takeaway legal principles highlighted for you. The summaries will be provided to you early next week. Without further delay, let's begin. The first case that we'll be dealing with today is on the topic of an application to interdict a disciplinary hearing. In this regard, Sibusiso Dube, who's a partner in employment practice in Johannesburg, will be dealing with the case. Go ahead, Sibu.
Thanks, Lusanda, and a good morning to everyone who is joining us. I believe the citation of the case will be put up, but the case relates to Lusanda Raphulu against the Modimole Mokgopong local municipality. This was an urgent application that was brought by the applicant to interdict a disciplinary hearing which would be held against him. The employee sought to interdict portions of the disciplinary hearing relating to additional charges that had been added by the employer. Initially, the employee had been charged on 2 allegations of misconduct relating to not following financial processes, and at a later stage, the employer added 2 additional charges where they alleged that the employee had committed fraud, alternatively financial misconduct. The employer also opened a case, a criminal case against the employee, which the employee was not aware of. When the employee became aware that there was a criminal case that had been opened against him, he then decided to lodge an urgent application with the Labour Court to interdict the disciplinary hearing based on the fact that there was a pending criminal case against him. In a nutshell, the employee alleged that proceeding with the disciplinary hearing would actually impact his constitutional right to a fair trial, as well as his right to remain silent. He was worried that if he proceeds with the disciplinary hearing with this criminal case hanging over his head, he may give evidence at the hearing which may later implicate him in the criminal trial. He was worried that he wouldn't be able to give evidence freely, and he would not be able to participate freely in the disciplinary hearing, which would then prejudice him. As a result, he then sought the order that either the disciplinary hearing is postponed sine die, or the employer must withdraw the charges against him which relate to the criminal case. Now, the application was considered on an urgent basis, and the court found that there was actually no basis to afford the employee any protection from the disciplinary inquiry. The court found that there are no exceptional circumstances which warrant interference, that the employee was actually seeking to benefit and seeking an advantage from the fact that the charges against him are so serious that they may amount to criminal conduct. And so the court found that there was absolutely no reason to interfere, that the employee was actually being disingenuous in seeking a postponement sine die, considering the fact that the criminal case could go on and take years before anything actually happens. Ultimately, the employee was actually looking to be absolved from attending the disciplinary proceedings, and the application was dismissed with costs.
Thank you, Sbu. Moving on to our next case. This case is on the much recently debated outcome from the High Court on parental leave. Sbu and his wife have a baby on the way, making him the perfect person to run us through this case. Thank you, Sbu.
Thanks, Lusanda. So I think by now we would have all heard something about the Van Wyk case, where Mr. and Ms. Van Wyk approached the High Court seeking an order to declare certain provisions of the Basic Conditions of Employment Act to be unconstitutional. Those provisions relate to maternity leave, parental leave, adoption leave, and commissioning parental leave. The brief facts is that Mr. and Mrs. Van Wyk were expecting a child. Mr. Van Wyk is employed and Mrs. Van Wyk is self-employed. Therefore, they felt that it was unfair for Mr. Van Wyk to only have 10 days of parental leave in circumstances where Mrs. Van Wyk would actually not be taking the full maternity leave, and it was actually Mr. Van Wyk who would stay home and take care of the child while Mrs. Van Wyk attends to business. That's really the reason why this application came about. So the court, in deciding whether or not these provisions of the BCA are unconstitutional, the reasoning was that the provisions of the BCEA are actually more concerned about the nurturing of the child, right? In doing this, the court also looked at the Children's Act, which places a lot of emphasis on the parents nurturing a child. So the judge in this case found that the provisions are actually not so much about the physiological needs of the mother, but rather that the provisions of maternity leave are about child nurturing. And having found that the provisions are actually more about child nurturing, the court then found that the provisions of Section 25, Section 25A to C of the BCEA are actually in conflict with Sections 9 and 10 of the Constitution, because they unfairly discriminate between a mother and a father, and they unfairly discriminate between sets of parents based on whether or not their children were born from the mother's pregnancy, from a surrogate relationship, or from adoption. As a result, the court then declared that these provisions are invalid and put in place interim measures while affording Parliament a period of 2 years to actually amend and correct the legislation. So the interim measures that the court put in place was that going forward, each parent would be entitled to 4 months' worth of parental leave. Obviously, I was very excited about this, thinking I'm off for 4 months, see you guys in April. But then there was obviously a catch. And the catch is that where there are two parents who are in, where there's a couple, that 4-month entitlement applies in respect of the couple collectively, and they have an election, right? They decide how they are going to apportion those 4 months between the two of them. So it could be that the mother gets 3 months and the father only gets 1 month out of that 4 months, right? So then I wasn't too excited anymore. However, it is very important, and I think this is the part that we ignore, and that's the Constitution, which provides that the declaration of invalidity is of no force and effect until and if the Constitutional Court makes a pronouncement on the order. So in other words, whilst there is an order declaring the provisions of the BCEA to be invalid at the moment and putting interim measures in place, there's a further step that needs to happen, and that is the Constitutional Court first has to confirm that order, and that has not happened yet. So what that means is the BCEA, as we know it, still applies. So I only get 10 days parental leave. And this will be the case until the Constitutional Court has made or has confirmed the declaration of invalidity. So until that happens, we just apply the Constitutional Court as is. There may be changes in the future, and if those changes are made, if the Constitutional Court confirms the High Court order, then obviously that will have an impact on parental leave or on parental leave in the workplace, and policies will then have to be amended to make sure that they are in line with either what the High Court judgment entails or what the Constitutional Court may find going forward. Thanks, Lou.
Thanks, Lou. Very interesting. We're now moving on to the topic of restraints of trade. Restraints continue to be very contentious in our law. We'll be dealing with two cases in this regard. The first will be presented by Melissa Cogger, who's a senior associate in our office in Cape Town. And the second one will be presented by Nadine, who's a partner in our office in Johannesburg. Thanks, Melissa.
Thanks, Lusanda. Good morning, everyone. So I'm going to be discussing the case of Avis Southern Africa, Pty Limited and others versus Porteous and another. It's a decision of the High Court that took place last month. And this particular case dealt with whether a restraint of trade had transferred with the business as a going concern in terms of Section 197 of the LRA. The respondents in this case were a married couple, Mr. and Mrs. Porteous, and they were both bound by restraints of trade when they worked for Avis, which is the car hire company. Then Avis was acquired by Barloworld, which was a third party, and Mr. Porteous then resigned as the COO, but his wife stayed on, and her employment was then transferred from Barloworld to another entity, Zeda Limited. And at Zeda Limited, she entered into another restraint in favor of Zeda. Then she transferred back to Barloworld and entered into a new employment contract and then to Zenith. And she resigned on the 31st of May, 2023. So the applicants in this case, being Avis, Zenith, and Zeda, being the car rental companies, approached the High Court on an urgent basis to restrain Mr. and Mrs. Porteous from breaching their restraints of trade covenants. In respect of Mr. Porteous, his case was struck from the roll due to a lack of urgency, and this was because he hadn't concealed the fact that he was going to render services to a direct competitor of the company when he resigned. And the employer had knowledge of this from the end of May 2023, but had only brought the application on the 17th of August 2023. So there was no urgency. Then the court looked at Mrs. Porteous's restraint, and she had commenced registering a company in Mauritius that intended to provide consulting services within the same industry. And it was discovered in June of this year that she had been transmitting work-related documents to her personal email address. And in relation to her, the court found that there was urgency that was established. So the main question was whether the restraint of trade that was entered into between Mrs. Porteous and Zeda had transferred from Zeda to Barloworld and then to Zenith. And The crux of this question relates to whether a protectable interest, such as trade connections and trade secrets, forms part of the goodwill of the business, and whether that goodwill transferred to the new employer. And the court held that when a business is sold, the subject of the sale is going to be determined with reference to the terms of the sale agreement. And if the goodwill forms part of a component of the sale, what the precise elements of the goodwill are going to be included in the sale is a factual question. Ordinarily, the benefit of restraint of trade is going to pass to the purchaser unless the parties intend the contrary to be true. But the court held that the statutory regime of Section 197 of the LRA doesn't change the legal position, and there's no automatic statutory assignment of the contractual rights created by a restraint of trade agreement. And there the court held the ordinary principles of cession continue to apply. And in that case, the companies had failed to show that the transfer of Mrs. Porteous's employment to Barloworld was part of a sale of a business that included, as part of the mercs, a cession of the goodwill of Zeda's business, which would have included the benefits of a restraint. And in addition to that, the affidavits failed to show a transfer of a business from Barloworld to Zenith. Now, earlier this year, there was another decision of the Labour Appeal Court in Beadle versus Slow Joe Innovations on the 17th of August 2023, where there was a transfer of a restraint in a Section 197 transfer. And the High Court in this case distinguished itself from those facts because in those facts, it related to an internal restructuring. Whereas in this particular case, Barloworld was a third party and there would be a requirement of a cession of those rights in the sale agreement. And moreover, there was no protectable interest that had been established in the restraint of trade. So the court said, even if we are wrong that there hasn't been a cession, there's no protectable interest and therefore it would be contrary to public policy to restrain the employee. So the main takeaway from this particular case, if you are dealing with a restraint in the High Court or the Labour courts, is that you must plead in your papers that as part of the cause of action designed to enforce the restraint, the facts that are going to establish that there was a transfer of a business which included a cession of the contractual rights that were created by the restraint and in favour of the new owner of the business. Thanks.
Thanks, Melissa. Nadine?
Morning, everyone. Similar to Melissa, I'm also dealing with a restraint case, which was also in the High Court and also, funnily enough, involved a married couple. The case is Imlink and others versus Mateo and others. Now, this matter concerned both restraint of trade, non-solicitation and confidentiality undertakings concluded in a shareholders agreement, together with the issue of unlawful competition. Now, the respondents in the matter, Rudolph and his wife, Elise, ran a transport and freight forwarding company called Clyroscan. And Rudolph was the controlling sort of mind behind Clyroscan. He was the de facto director and manager of the company. And during the course of last year, Clyroscan ran into financial distress, and Rudolph decided to approach another company, namely Imlink, the applicant in the matter, to come to the rescue of his struggling business. Now, Imlink and Clyroscan operated in the same field as transport and freight forwarding companies. They could be regarded as direct competitors in that they offered the same services to the same customers in the same market. Now, following various negotiations, Rudolph said to Imlink, "What I will do is I will bring my customer base to you, and you can have my customers. And in exchange, I want shares in the company." So they agreed that Rudolph would bring his customers on board for Imlink, and they would be Imlink's customers going forward, not Clyroscan's. And in return, he would receive 10% of the shares in Imlink. The customers were probably approximately 151 customers that he had very close personal relationships with, and he brought them across to manage them for Imlink, whilst his wife continued to manage and operate Clyroscan. Now, this shareholders agreement was concluded, which of course included a restraint of trade, which was signed by both Rudolph and Elise under the vehicle of Clarascan, and prohibited them for a period of 24 months from seeking to solicit their clients or providing any transport services to MLink's clients, and to keep confidential any information of MLink. The relationship turned sour fairly quickly within a year, and Rudolph decided to leave MLink. And shortly thereafter, it came to MLink's attention that they were breaching the restraint of trade and in effect unlawfully competing with the company, and that they were diverting business away from the customers of MLink to third-party service providers, so the customers would use other service providers to transport their loads. Now, unfortunately, and perhaps on the basis that this was a judgment or a matter at least heard on an urgent basis, the judge, Adams J, did not actually set out the evidence in the judgment, so I don't have any sort of juicy facts for you in respect of what conduct took place. But what the court did confirm, and what Melissa has already alluded to, was that there are two kinds of proprietary interests that can be protected in restraints of trade. The first is a relationship with customers, suppliers, or any other sort of persons that constitute trade connections. And this really is referred to as the goodwill in the company. The second is, of course, confidential information, or any information that is undertaken to run your business, that if it got into the hands of another entity, could be used to gain a competitive advantage. Now, in this matter, it was fairly evident that MLink had customer connections and confidential information, and that Rudolph, as a sort of agent on MLink and a salesperson, had used this information to obtain a secret profit in trying to establish sort of diverting business and generating money for service providers. And it was not him in his capacity as an agent allowed to do that, and this would constitute unlawful competition, as he exploited MLink's customer connections and confidential information to its detriment. They were making use of the customer relationships, they were making use of the confidential information, and allegedly some of the business was being diverted to another company, which was Rudolph's son's company. So it all became a bit messy. But ultimately, what the court found is that they were in breach of the restraint of trade undertakings. There could be no doubt of this. But further than that, there was unlawful competition, whether there was restraint undertakings or not. The use of confidential information to sort of to the detriment of another company or to gain a competitive advantage was prohibited. Now, the restraint was unequivocal in its nature. It was fairly clear. Restraints are valid and enforceable, and it's the onus is on the party challenging the restraint to show that it was unreasonable and against public policy. The parties in this case did not do so. They did not deny not having confidential information. They did not allege that they didn't have customer connections. It was fairly well demonstrated that these proprietary interest exists and the restraint was reasonable. So in the circumstances, the High Court did grant an interdict on the basis that a clear right was established. There was apprehension of irreparable harm, and of course there was no other remedy available to the parties in these circumstances. So just in terms of key takeaways, again, restraints on the face of it are valid and enforceable, and there's often a common misconception that they're not worth the paper they're written on, but it is not true. And specifically in this case, yes, it's slightly different because it was a shareholders agreement. We ordinarily don't often see restraints of a 24-month period being enforced in an employment context. But importantly, this case is obviously distinguishable in that it was really non-solicitation undertakings and preventing them from soliciting clients and not preventing them from taking up employment or gaining employment. So that issue in this case, you know, which is often a sticking point in the Labour Court in respect of preventing someone from earning a living, wasn't applicable, and the court had no hesitation in enforcing the 24-month restraint.
Thanks very much, Nadine. Before we move on, there's a question for you, Sbu, on the issue of parental leave. The question is, does the couple have the choice to take the leave simultaneously or consecutively?
Sure, thanks, Lusanda. It's really up to the couple, so it's their election. As long as they notify their employers of the time periods when they'll be taking the leave.
Great, thanks, Sbu. We're now moving on to the topic of misconduct. We'll be dealing with 4 cases under this topic. The first will be dealt with by Amandla Makhongwana, who's an associate in our office in Johannesburg. the second by Ayanda Nkabinde, who's a senior associate in our office in Johannesburg, the third by Talita Laubscher, who's a partner in our office in Johannesburg, and the fourth by Nadine. Go ahead. Thank you, Amandla.
Good morning, everyone, and thank you, Lusanda. I'll be dealing with the case of Van Dunder versus Sibanye Stillwater Limited and others, which was decided in September of this year. The facts of this case are somewhat disheartening, especially in the context of our constitutional dispensation, and this was also noted by Judge Mahosi in his judgment. So at the time of his dismissal, Cornelius Van Dunder was employed by Sibanye Stillwater as its acting shaft engineer. This role carried with it the responsibility for the supervision and management of discipline. And it transpired that on the 4th of October 2018, Mr. Van Dunder had instructed 2 junior employees who were late for a safety meeting to report to his office for an appropriate disciplinary action. When they did so, Mr. Van Dunder gave them a choice between facing a formal charge of misconduct or submerging their heads in a fish pond on Sibanye's premises. The employees chose the latter, and the submerging occurred with some of their colleagues taking photos and videos of them. Embarrassed and denigrated and belittled by the submerging, the employees later lodged a formal grievance, and Mr. Sibanye was then disciplined and dismissed following that. Aggrieved by his dismissal, Mr. Van Dunder approached the CCMA challenging both the procedural and substantive fairness of his dismissal. During the arbitration proceedings, Mr. Van Dunder's evidence was that there was a well-established practice and tradition of submerging employees in the fish pond, and that such was also known to exist by Sibanye's management. And in some instances, there were pictures of employees being submerged displayed on notice boards and meeting rooms. Mr. Van Dunder and his witnesses further adduced evidence that the submersion of employees in the fish pond was used as a form of alternative discipline to celebrate and in certain instances for team building purposes. Obviously, Sibanye denied Mr. Van Dunder's contention that there was a well-established practice or tradition of submerging employees in a fish pond as an alternative to discipline. Sibanye indicated that it had a disciplinary code which came in effect in September 2013, which replaced all previous regulations, policies, and procedures, and which Mr. Van Dunder was trained on as a senior employee responsible for the enforcement of the disciplinary code. The code itself did not make provision for any alternative disciplinary process of submerging employees in the fish pond. At the CCMA, the commissioner accepted Sibanye's version, finding that the alternative fish pond discipline was a rule created by the employees themselves without the endorsement of Sibanye as the employer, especially considering the instances where the disciplinary code was followed even for minor offenses. So it could not be that Sibanye endorsed the submerging. The commissioner further accepted Sibanye's assertion that even if the alternative fish pond discipline was a tradition, such was contrary to Sibanye's rules, processes, codes, and values, and had the potential to infringe on the fundamental human rights of the employees. The commissioner ultimately found Mr. Van Dunder's dismissal to be procedurally and substantively fair. The then disgruntled Mr. Van Dunder instituted review proceedings at the labor courts, alleging a series of irregularities being committed by the commission. At the labor court, Mr. Van Dunder relied on the Van Breda and others versus Jacobs and others judgment, wherein the court found that a practice must be certain, uniformly observed for an extended period of time, and be reasonable for it to be recognizable law. The labor court found that there was no certainty in the application of the alleged practice, as some managers allowed, condoned, or even instructed subordinates to submerge their heads, toes, or feet in the fish pond as an alternative to discipline, to celebrate, or to build team spirit. So there was just no certainty in respect of which this practice was applied. The Labour Court found that the practice was also not uniformly observed for a long time because there were other operations who were not practicing such submerging tactics. Lastly, the Labour Court found that in a democratic society where everyone has inherent dignity and the right to have that dignity respected and protected is enshrined in the Constitution, such a fish pond submerging practice as an alternative to discipline was degrading, humiliating, and therefore impacting on the employee's dignity. In this respect, the tradition was not reasonable. In respect of the sanction, the Labour Court held that the Commissioner considered the totality of the circumstances of the matter, including the importance of the rule and the gravity of its contravention, and found that being in a position of trust, Mr. Van Tonder was obligated to protect the employees from behavior that impaired their dignity. And furthermore, the Commissioner had found that Sibanye could not have been seen by its international partners and affiliates to promote and associate itself with conduct that humiliates and degrades its employees, especially where such is also opposed to its values and principles. The Labour Court could not falter the Commissioner's finding, as the Commissioner had dealt exhaustively with the evidence before him. And in this regard, the Labour Court agreed with the CCMA that Mr. Van Tonder's dismissal was substantively and procedurally fair. Thank you, Lusanda.
Thanks, Amandla. There's a question here for you. I've just asked for clarity. I'm not clear on the question, but it says, good morning, Amandla. Please repeat the practice case law just used.
Thanks, Lusanda, and thank you for the question. The case law is Van Breda and others versus Jacobs and others. We'll send the full citation.
Yeah, the case citations are all being placed on the chat. Thanks, Amanda. Ayanda?
Good morning, everybody, and thank you, Lusanda. So the first case with which I will be dealing this morning is Crest Chemicals versus Thabiso Pete and others. This is a review application, and it's a review of a decision of the CCMA, and it involves the appropriateness of sanction in instances where an employee has been insubordinate. So the facts are fairly narrow. In 2010, Mr. Pete was appointed as a debtor's clerk at the company, and included in his role at the time was to load payments and receipts on the company system. Sometime after that, maybe a few years, the company goes through a restructuring process. And as a result of that restructuring process, the job involving loading payments and receipts onto the system are reallocated to another employee. So Mr. Pete is no longer responsible for that particular function. So fast forward to the 16th of November, 2015, Mr. Pete is called into a meeting with his line manager. And during that meeting, the line manager wants to discuss reallocating that duty back to Mr. Pete, asking him to essentially onboard that duty once again. And as the company tells it, Mr. Pete, he left the meeting after just point blank refusing to take on that responsibility once again. And so the line manager, she felt that her authority was being undermined, and she subsequently decided that this was worthy of a charge, and indeed Mr. Pete was charged. He went through a disciplinary hearing, and the chairperson of that hearing found that his conduct was grossly insubordinate, and he was subsequently dismissed. So, of course, being aggrieved by this decision, Mr. Pete subsequently goes to the National Bargaining Council for the chemical industry. And there the commissioner finds that, yes, indeed, in his conduct, Mr. Pete was insubordinate. But the arbitrator finds that dismissal was far too harsh. Instead, he says that what would have been more appropriate was a final written warning, which would have been valid for 12 months. So that is the ruling, or that is the award that the arbitrator eventually issues. And in addition to the final written warning valid for 12 months, he also awards retrospective reinstatement. So, of course, the company decides that they're going to take this matter up all the way to the labor court because they feel quite strongly about the conduct of Mr. Pete and just walking out during a meeting where he had been asked to take on these additional responsibilities once again. So the labor court, in their analysis, they begin, of course, by restating the test for review applications, and that is that it's a decision to which a reasonable decision maker could not come. And if a decision is found to be so, then it would be reviewable. But the labor court also clarifies when an act of insubordination or even insolence would be dismissible. And there the test is simply that it must be serious and it must be willful. And that is determined with reference to a number of factors. So in deciding that the bargaining council was correct in saying that the sanction of dismissal was too harsh, the labor court effectively looked at three main factors in this dispute. The first one was that Mr. Pete had a belief that he was being consulted during that meeting. So he did not believe that he was being instructed to take on the responsibility, but instead that he was being spoken to about this, and it was something that he could consider. And this was primarily because of the previous Section 189 process that had resulted in his responsibility, or that responsibility, previously being taken away. The second factor that the court looked at was the fact that the line manager herself had conceded that the reallocation could result in a change in title. But that was depending on how well Mr. Pete did in that respect. But this is important because it would mean that agreement would be something that ought to be secured between the parties. And perhaps then that gives credence to Mr. Pete's original belief that he was in fact being consulted and that he could communicate with the company and with his union before deciding to take this on. And then the final factor that was also worth consideration according to the labor court was the fact that the relationship between Mr. Pete and his line manager was in fact a cordial one. In fact, during her testimony at the arbitration, she said that his walkout was spontaneous. It was an anomaly. And in fact, she had said that aside from this instance, she actually trusted him implicitly. And what this all showed was that the trust relationship was not broken. But more importantly, it showed that, or in fact, all of these factors combined showed that Mr. Pete's conduct was not premeditated, and it certainly wasn't willful. It was not aimed at undermining the employer's authority. But what the court also said, and perhaps this is maybe a broader commentary on review applications, they said that when the company brought the review application, they sought to cherry pick particular points or particular facts that they believed the commissioner had not considered in his evidence. But what review applications in general require is a consideration of the totality of the circumstances. So it was inappropriate, for instance, for the company to point to just a clause in the disciplinary policy, which says that insubordination is a serious offense, without looking at the totality of the circumstances and the evidence that has been provided. So with that said, the court decided that the review application, or rather that the award was reasonable and that the review application ought to be dismissed. Thank you.
Thank you. Thanks, Ayanda. Talita?
Thank you, Lou. Good morning, everyone. I'm sure you are all looking forward to the end of year break, and I hope that you will all make it until the time that you're able to take a bit of a rest. COVID is still with us, definitely in the making its way through the case law, and we are dealing today with a case where an employee tested positive for COVID, but then came to work. This is the matter of DHL Supply Chain Pty Limited and others, and the employee in question was Mr. Themba Diamond. Now, Mr. Diamond worked for DHL and he didn't feel well. So he went to his doctor, and this all happened in the midst of our lockdown. This was in July 2020. So if you take yourself back, that was lockdown time, and there were all kinds of rules and employment measures in place. We can remember. So yeah, he felt ill. So he went to his doctor. His doctor said, no man, you're lucky, you just have the flu. He didn't get better. And he thought to himself, let me just take a COVID test. Then he arrived at work and his access card was blocked. He was angry at that, and he asked the security guard why this can be. And the security guard said, just go to the clinic. They have a clinic on site. He went to the clinic. The nurse examined him, and she said, but you cannot come to work if you are not well in these circumstances. He allegedly spat at her. And he also said in that examination that he had body pains, upper respiratory blockages, and he was awaiting his COVID test. He had been at a group gathering within 14 days, and the nurse then said, well, you can't be here if you are waiting for your test, and lo and behold, the test was positive. About 4 months later, the company instituted disciplinary action against him, and the charge was that he had endangered the health of his fellow employees, and in brackets that he spat at the nurse. He was dismissed, and at the CCMA said that his dismissal was unfair. First, it said the charge was vague. He didn't know how he had committed misconduct. The charge was you endangered the health and safety of fellow employees, and in brackets it said he spat at the nurse. It's not very vague, I would think. Secondly, the commissioner said the employer didn't prove that a rule was breached, because there were no documents that were presented to the commissioner in relation to the whole issue of not coming to work if you are awaiting a positive, or well, a COVID test result. So the commissioner said this was an unfair dismissal, and the employee was reinstated. Aggrieved with this decision, DHL took this on review to the Labour Court, and the court then took into account that this happened in the midst of the COVID pandemic. The court said the fact that there were no documents in relation to the rule was completely unreasonable, because there was direct evidence by the witnesses for the company that explained how it was communicated to employees what to do in the event that they are ill, if they had gone for a test, that they needed to self-isolate and stay away from the workplace. And the commissioner failed to take that into account. The commissioner also said there was nothing vague about the charge. And in fact, this employee's conduct of going to work while awaiting his test was certainly in breach of the rule, that he needed to keep the health and safety of his fellow employees front of mind. The court said a further factor that supports the contention that the applicant has discharged the onus is that the employer may dismiss an employee for committing misconduct when that employee should reasonably have known that the conduct constituted dismissible misconduct. It cannot be unfair to dismiss an employee who knowingly and deliberately expose others at the workplace to a deadly virus. The contact with the security guard and the nurse was already enough for the employee to have breached that rule, and he had an obligation himself as an employee to provide a safe environment. So the court upheld the application, and it held that the dismissal was in fact fair.
Thank you. Thanks, Talita. Nadine?
Thanks so much, Lou. So I'll be dealing with the last misconduct case, which is Marion Roberts versus CCMA and others. Now, this matter concerned misconduct in the form of poor work attendance, and did involve an arbitration award that was taken on review and then on appeal to the Labour Appeal Court. But briefly, Marion Roberts employed the employee at issue as an assistant electrician, and in November 2019, the employee was charged with poor work attendance, in which it was alleged that the employee was absent from 29th of October and 4th of November. He also continuously misused sick leave. Now, at the disciplinary hearing, when it commenced, the employer raised new evidence that the employee had also been absent on others' days, being the 14th, 21st, 28th, and 30th of October, and that the employer's code of conduct provided for dismissal as an appropriate sanction where an employee was absent without permission for a period of 5 working days or longer. The date of the 29th of October was, however, abandoned, as the employee had not been absent on that day, but ultimately in the circumstances, the company found that he was guilty of the charges and dismissed him. Aggrieved by his dismissal, the employee referred a dispute to the CCMA. And at the CCMA, the evidence led by the company was led by its human resources officer. Now, the human resources officer wasn't at the disciplinary hearing. They weren't involved in the investigation, and ultimately they attended the CCMA with a copy of the charge sheet and a copy of the clock-in records and sort of led that as evidence. So the employer's witness wasn't able to testify on the allegation about the employee having previous concerns relating to unauthorized absence, or even to explain whether the charge was that the employee was absent for 5 days or whether he was absent for 5 consecutive days. Now, the employee, however, brought a witness who was a fellow employee at the company who testified that in his 10 years of employment at the company, he had understood that it is a dismissible offence to be absent from work for 5 or more consecutive days without authorization. And the employee's case was thus that he had to be absent for 5 consecutive days in order for it to be a dismissible offence. Now, the arbitrator at the CCMA did express doubt as to whether the charge was clear. And this was obvious. As I said, the charge was he was absent from 29th of October and 4th of November. It wasn't clear whether that was from 29th to the 4th or whether that was on the 29th and on the 24th separately. But leaving this aside, the arbitrator said that the employee knew the charge that he was responding to, and despite the wording of the charge, the reason for the dismissal was valid, and to find otherwise would be overly technical in these sort of circumstances. The arbitrator said the employee wasn't reliable. The employee apparently in evidence couldn't recall whether he was absent or not, but in cross-examination denied it. And it was fairly clear that he'd breached a rule of taking leave without authorization, and on that basis, and the fact that it was a period of 5 days, his dismissal was justified. The employee was upset by this and took the award on review to the Labour Court. And at the Labour Court, the Labour Court considered 2 grounds for review. The first one was the admission of hearsay by the employer's human resources officer, and the second one was the issue of potentially irregularity in the fact that the employee was not guilty of misconduct in respect of the charge sheet, which did not constitute a dismissible offence. The charge sheet only had 2 dates, not other dates, and therefore there was actual no dismissible offence. Now, the Labour Court, in considering whether this was a reasonable decision that had come to, said the Commission was wrong in admitting the hearsay evidence led by the company. And in addition to that, he misconstrued the inquiry that was before him. On the basis of the charge sheet, the employer had only established the employee's absence on the 4th of November. It was agreed that he wasn't absent on the 29th. So if the employer had wished to rely on the extra dates raised at the hearing, it should have amended the charge sheet. And on this basis, since he was absent only for 1 day, his dismissal was not fair in the circumstances, and they said it was substantively unfair, unfair dismissal, and ordered his reinstatement. Now, the company then took this on appeal to the Labour Appeal Court. And again, the Labour Appeal Court focused on the 2 grounds of review raised. In respect of the hearsay evidence, which really did pertain to the human resources officer speaking to the timesheets that he wasn't sort of aware of and the charge sheet that he wasn't involved in, etc., not bringing any other evidence. The Labour Appeal Court did agree that this constituted hearsay evidence, but also noted that it wasn't actually incumbent on an employer to always call witnesses to testify directly to documents in which it's relying on in proceedings. And more so that the fact that the arbitrator did not expressly consider the law in relation to hearsay evidence, namely the Law of Evidence Amendment Act, did not mean that he had not applied his mind to it. So under the Law of Evidence Amendment Act, hearsay evidence is inadmissible unless the parties agree to it being admitted, or it should be admitted in the interests of justice. Now, in this case, the Labour Appeal Court said it was admitted in the interests of justice, and it is not unreasonable to admit evidence of this nature in these circumstances. So they found, different to the Labour Court, that the Commissioner, or at least the arbitrator, had considered the issue of hearsay, had elected to admit it, and this cannot be categorized as unreasonable. Now, moving to the issue of the guilty verdict in respect of misconduct, it really was the issue of the dates. Now, the employee said he was charged and absent from work for 2 days. The hearsay evidence was in respect to another 4 days. The employer would not have made out their case had the employee been absent without permission for 5 days, had it relied on the charge sheet that was there. Now, the court noted that when formulating charge sheets, the principles are that the accused employee must know of the precise charge being brought against him and also be afforded the opportunity to prepare and be able to respond to that charge in a disciplinary hearing. And in this case, even though it was raised at the disciplinary hearing, the additional dates, and the employee could answer to that, they found this process was unfair. He didn't get sufficient time to consider this, and on this basis, the additional dates should not have been admitted. The company did try and argue that we didn't need 5 days. We could have used the 2 days. It's still leave without absence, but the court sort of said, well, why did you add the extra days then? You know, if you didn't need the 5 days for dismissible offence, you should have just relied on the charge sheet and not added the extra days. So in summary, the court found that the commissioner had misconstrued the inquiry. It was not for the chairperson or the arbitrator of the CCMA to interpret the charge in a manner that was different to its ordinary reading. If the employer wanted to charge the employee for those days, they should have amended the charge sheet and given him an opportunity. And for what he was found guilty did not constitute a dismissible offence under its own code of conduct, which was absence for 5 consecutive days without authorization. So just some, I think, obvious key takeaways is pay attention to the drafting of charge sheets. Again, whilst they're not required to be drafted in an overly technical manner, they are required to be drafted in sufficient detail to allow the employee to actually respond to the charge. And it should be clear, which the charge in this case wasn't. And to the extent that you do intend to amend or supplement charges, which often employers do and they reserve the rights to do, it is important to, of course, afford the employee an opportunity to consider the supplemented charges and to prepare to answer them in order to ensure a fair process.
Thanks, Nadine. Very important principles. We'll now be moving to the issue of assault. We'll be dealing with one case in this regard, and Amandla will be presenting the case. Thanks, Amandla.
Thanks again, Lou. And to Nadine's point, this case also touches on the charge sheet. So in Mess Stores Pty Limited versus the CCMA, which was decided in September 2023 as well, Mr. Thomas Meti was employed by Game in Everton, and Game received an ethics call wherein it was reported that Mr. Meti was assaulting shoplifters. There was an investigation conducted, and subsequent to that, he was called to a disciplinary hearing to answer to a charge of assaulting customers. Mr. Meti's contention was that he did not assault anyone, and he merely touched shoplifters and not customers, because to him there was a clear distinction between who is a customer and who is a shoplifter. And there was also a clear distinction to him as to what constitutes assault. For him, what he was doing was simply touching the shoplifters, not necessarily assaulting them, as he contended that he did not use deadly force, but just minimum force. Obviously, after his dismissal, he referred an unfair dismissal dispute to the CCMA, and there he maintained his contention that he never assaulted customers, but he merely used minimum force to restrain shoplifters. The commissioner agreed with Mr. Meti and found that his dismissal was substantively and procedurally unfair. Naturally, Mess Stores approached the Labour Court to institute review proceedings, alleging that the commissioner did not apply his mind and the likes. Before the Labour Court, the court said they needed to consider the evidence presented at the arbitration, and then there was a need to consider the record itself. There were various issues before the Labour Court brought by Mess Stores in respect of the procedural fairness aspect. The commissioner had found that there was no proper investigation of the alleged misconduct, and that Mr. Meti was not given a sufficiently detailed charge sheet, and his rights were not read to him or were not set out in the charge sheet itself. And Mr. Meti then also brought an inconsistency issue, which he had not previously raised during the disciplinary hearing. So at the labor court, Ms. Stores indicated that it had a clear disciplinary code that prohibited employees from assault. And that disciplinary code governed conduct in its workplace. And they also indicated that assault was taken very seriously as it impacted on the image of the business and could potentially result in claims against it. In that regard, it led evidence to the fact that it had a duty to protect its customers who enter their business premises, and that the staff was responsible to also protect the customers and not to assault them. Mr. Meti's evidence still maintained that he only used minimal force as opposed to deadly force, and there was a distinction between who is a customer and who is a shoplifter. The labor court, in dealing with the procedural aspect of the dispute, considered the judgment in Avril Elizabeth Home for the Mentally Handicapped versus the Sisime and others, and reiterated that an employee accused of misconduct has the right to state his or her case before any decision is made as to whether the employee committed the misconduct, and if necessary, what the appropriate sanction should be. The labor court found that the commissioner had misconceived the test for procedural fairness and held that the standard for a disciplinary charge sheet is not the same as for one in a criminal case. The information in the charge sheet must be sufficient to inform the employee as to the nature of the allegations against him or her, for him or her to know what the case to meet is and to prepare the necessary defense. On the issue of the investigation, interesting enough, the commissioner stated that had the matter been properly investigated, the company would have not called shoplifters its customers. And the commissioner wondered why, after a thorough investigation, shoplifters were still called customers. The CCMA arbitration, as recorded in the judgment itself, shows the case of employee activism by the commissioner, where he seemingly considered the evidence of one party over the other. Nevertheless, the labor court found that all that is required is for the employer to grant the employee an opportunity to state his or her case before a decision is made. And in this regard, the labor court found that Mr. Meti was indeed afforded a right to a hearing before an independent chairperson. His rights were read to him before the hearing commenced, and he did not raise any objections to indicate that his rights would be compromised. In that instance, the labor court found that his dismissal was procedurally fair. And in respect of the allegation of consistency, the labor court held that such must be raised at the outset of the proceedings and in a concrete fashion so as to afford an employer the opportunity to deal with it. The allegation will be concrete where the people who were treated differently are identified and the basis upon which they ought not to have been treated differently is clearly set out. Further, the labor court held that consistency is but an element of fairness and not decisive of the outcome on the determination of the fairness of dismissal. And in this case, Mr. Meti was unable to show any inconsistency because the employee he had identified allegedly assaulted a colleague and was not dismissed. But then he had no other facts other than that it was hearsay, and he was not familiar with what happened in that case. So the court found that, well, you can't even show what transpired that makes your situation inconsistent. In deciding on substantive fairness, the arbitrator had found that there was no tangible evidence that Mr. Meti assaulted customers. Obviously, because now the commissioner was of the view that had the matter been properly investigated, Mestos wouldn't have considered shoplifters its customers. So on that basis, it was at fault. And that indeed, Mr. Meti had used minimal force, which is not deadly force and could not be perceived as assault. The Labour Court held that the legal requirements for the offense of assault in the workplace are the intentional and unlawful application of force, however slight, to the body of the complainant, or the threat that such force will be applied. Since assault does not require the actual use of force, the severity of force applied is irrelevant. In the circumstances, the Labour Court found the Commissioner's findings that Mr. Meti's application of minimal force was no assault was unreasonable. The Labour Court further held that an employee accused of assault can raise the defense of provocation or self-defense, which would negate the unlawfulness of the assault. But such can only happen where the employee admits to having assaulted the other person. In this regard, the Labour Court found Mr. Meti's dismissal to have been procedurally and substantively unfair. Sorry, to be found the dismissal to have been procedurally and substantively unfair and opposed what the Commissioner had indicated. As again stated, this is a case where we see our commissioners taking the side of employees in such instances. And it is well to note that what may necessarily be set out in the charge sheet, as Nadine had indicated, all that is required is that it is sufficiently detailed so as to enable the employee to understand what is it that they are defending against. Thank you, Lusanda.
Thank you, Amandla. We're now going to move on to the issue of absence due to ill health, specifically the issue of medical certificates. Ayanda will be dealing with the case in this regard.
Thank you, Lusanda, and hello again. The second case with which I'll be dealing is Epibiz versus CCMA and others. Now, this is a review application that places some focus on medical certificates and the information that is to be disclosed, about the illnesses that an employee suffers from. I find the judgment to be quite a passionate one, and perhaps it is reflective of the maybe troublesome nature, or at least contentious nature of medical certificates that are advanced by employees. So the facts are a little long. It begins in August of 1989, where the employment relationship with the employee commenced. So, I mean, for the next 27 years, the relationship continued actually without incident. And then in May of 2016, the employee was suspended and charged for misconduct. She then goes through a hearing, and ultimately it's found that she's not guilty. So, I mean, there's no real reference to the nature of the charges or anything like that. But why this matter has come to the court or has reached the stage was because on the 24th of August, 2016, the employee was asked to return to work, but she refused. So instead, she submitted a doctor's note, and in that doctor's note, she was booked off for basically the whole month of August until the end of August. And in the medical certificate, the nature of the illness is listed as consultation. Yeah, so on the 29th of August, the employee then this is the day before the expiry of the first medical certificate. She goes back to the doctor and she produces a similar note to the employer, and this one also booking her off for the month of September. And again, the nature of the illness is simply listed as consultation. So on the 13th of September, the employee then goes to a clinical social worker whose name is Miss Mitchell. So after consulting the social worker, Miss Mitchell produces a report. And in that report, she says, she had a discussion with the employee, and, the employee took me through everything that has happened, the suspension and the disciplinary hearing. And as a social worker, I have come to the conclusion that she was suffering from shock as a result of the suspension and the disciplinary proceedings. She's been at the company for about 27 years. So she was completely blindsided by this, and she did not expect it. The social worker also said that the employee was suffering from anxiety. She was exhibiting symptoms of depression, etc., etc. So, all in all, it was a grim picture that was drawn by the social worker. And so, sure enough, 2 weeks later, a further doctor's note is produced, but breaking the trend, it said in that doctor's note that the nature of the illness is stress and insomnia. But then a month later, and that doctor's note also booked the employee off from the 1st of October through to the 30th of October. Then on the 28th of October, there's a further doctor's note. And this one says, or rather, they revert back to the original trend, and the nature of the illness disclosed is consultation. And then on the 31st of October, the social worker once again produces a further report claiming that the employee is suffering from PTSD. So, at this stage, the employee has effectively been booked off for 3 months. And in all but one of the medical certificates, there is the nature of the illness is simply listed as consultation, which, by the way, if it's not clear by now, is not a medical diagnosis. So on the 3rd of November, the company decides, they are sick of this, and they write to the employee. And in the letter to the employee, they record numerous attempts that the company had made to engage on, whether the employee can continue to be employed. What was set out in Ms. Mitchell's reports to the company was that, look, she's very stressed. She actually, we need to think about alternative methods of work or alternative means to accommodate her in the workplace, because, going to the workplace is just going to exacerbate her stress and her anxiety. And, the employer would then go back to her and say, well, look, come, let's talk, please explain, what is the nature of your illness? Consultation is not quite satisfactory. So let's talk about it. And throughout the process, throughout the 3 months, the employee refused to engage on that basis and just kept producing those doctor's notes. So in this letter that the company writes to the employee, they ask her to submit written reasons as to why her employment contract should not be terminated on the basis of what she has already said, and her practitioners and representatives have already said, is an inability to work, incapacity to perform her job. So on the 13th of November, or perhaps sometime before that, the employee approaches legal representatives, and on the 13th of November, they write back to the company. And they essentially say, well, look, as the employer, you have to look at alternatives short of dismissal. Those have to be considered. And they cite Schedule 810 of the Labor Relations Act. And they say that that requires the parties to investigate alternatives, such as, working from home and things like that. So the company receives this letter and they decide, look, you said nothing, you haven't really helped us in our inquiry, nothing you've advanced has actually spoken to what we are actually trying to investigate. And on that basis, they say that, or they decide to terminate the employee's employment. So perhaps predictably, the employee goes over to the CCMA, and at the CCMA, the commissioner says that the employee's dismissal was substantively and procedurally unfair. So the company decides that they're going to go to the labor court. And the labor court, as I said, produced what is quite a passionate judgment on the issue of medical certificates and the nature of the inquiry that an employee is supposed to conduct. And in doing so, they focused on, I guess, two legal findings. The first one was that the arbitrator had misconstrued the law. So first, they say that Schedule 810 of the LRA never contemplated an illness called consultation. And of course, that has to be correct. And then what the court goes on further to say is that that schedule also doesn't really consider or contemplate stress or PTSD as an illness. So anyway, the employee, and then the court also pointed to the fact that the employee refused to come to the party to explain her illness. During the arbitration, in fact, when she was asked to explain what does consultation mean, well, she said, look, I don't know, I'm not a doctor. You can ask the doctor what consultation means. So, I mean, even at the arbitration, the employee either refused to or simply could not explain what was meant by consultation, and she refused to go into the detail of what was wrong with her. But what's also more important was that the report from the social worker, the court said that that report constituted hearsay, and that was because it was not supported by an affidavit. And that's from a legal principle that I believe was adopted back in 2005 or thereabout, where the court said that a medical certificate or a doctor's note must be supported by an affidavit, in which case it will not be hearsay evidence. And so the court found that on that basis, the arbitrator had actually misconstrued the law. The second finding that was made was that the arbitrator had failed to consider material evidence. And in this respect, the most important was that the employee's evidence was that she could not work from home. She had said so herself, that because the documents were confidential and also just the nature of the task that she was performing, she just could not perform it at home. So it was not viable in that circumstance for the employer to continue to pay her. And so all in all, what the court found was that the employee's dismissal was in fact substantively and procedurally fair. And that was primarily because of the employee's failure to partake in a process to try and to investigate what alternatives could be explored, but also the consistent concession that she was too sick and incapacitated to work. And in fact, what was quite significant and perhaps a reason for the court's passion in this judgment was the fact that at some stage, the employee had made numerous proposals to the company about, how best to end this relationship. I mean, at first they said that let's lodge a claim with Cogger, because she felt that she had been injured on duty as a result of the disciplinary hearing. There were further suggestions such as the workman's compensation, and the company had refused all of these because they said that they did not want to be party to a fraudulent claim, which was prudent and correct on their part. But what I want to just maybe emphasize as a parting shot is one of the quotes left by the judge in the judgment. And he says that medical certificates are instruments used daily, in some instances, to perpetuate exaggerated or feigned illness. An employee who was too sozzled over the weekend cannot attend to work due to babalas or hangover, simply goes to his or her medical doctor to obtain a medical certificate or sick note. A student ill-prepared for his or her examination resorts to the same tactic to be afforded an opportunity to write at a later stage. And the judge also goes on to speak about the civic duty that medical doctors have about giving or producing medical certificates. He warns them to be conscious of their Hippocratic oath and routinely stay true to its terms and spirits. And in fact, what the judge goes on to say is that he believes that the issue of medical certificates actually requires legislative intervention because of issues like this. And yeah, I found that to be a very interesting judgment, a very strong judgment. And I think perhaps the key takeaway is that, an employer can only go so far as to investigate particular issues, but an employee must come to the table in processes like this, in investigating alternative dismissals. And certainly an employee cannot be so vague as to say that the nature of their illness is a consultation. So yeah, thank you. Over to you, Lusanda.
Thanks, Ayanda. Yeah, I mean, the issue of medical certificates is very contentious. So the passion on behalf of the court is understood. And in our experience, employers also become very passionate about this very frustrating issue on how to deal with continuous medical certificates. So thanks so much for that. 2 more topics to go, 2 more cases to go. The next topic is whether an acting appointee can have a reasonable expectation of permanent appointment onto the role, and Talita will be dealing with this judgment. Thanks, T.
Thanks, Lou. This is a judgment, let me just see, Eskom Holdings and Solidarity on behalf of Nkabinde. She was the first respondent. The person who was appointed was Christina Mhlina, and then the commissioner and the CCMA were the other respondents. So in 2015, Eskom underwent an organizational restructuring and a new position, Senior Business Enablement Manager, was created. Ms. Nkabinde was at the time the Middle Manager Security Investigations, and she was appointed to this role of Senior Business Enablement Manager in an acting position from the 1st of September 2016 to the 17th of May 2017. During this time, this position was advertised and quite a number of applicants applied for this role. Ms. Mhlina was appointed, and disappointed with this decision, Ms. Nkabinde wrote to her employer, and she said that she was informed that she didn't get this role. Can I please have detailed feedback on my application and interview results so that I can identify my shortcomings for development purposes? No response. So on the 10th of May 2017, she addressed a second email to Mr. Du Toit, and she then, on the 26th of May, lodged a grievance because she wasn't appointed. She then also referred an unfair labour practice dispute to the CCMA, and again on the 5th of July addressed a letter to Mr. Du Toit in which she said, "I've not yet been informed why my application was unsuccessful." And again, she said it is for purposes of identifying her shortcomings, and she wanted reasons within 7 days why she wasn't appointed. She also lodged an application for documents in terms of Rule 29 of the CCMA rules, and that is the rule that deals with the discovery of documents in the CCMA. So the matter went to the CCMA, and the facts of these two appointments were as follows. Ms. Nkabinde had a national diploma that she got in 1991, and she had a Bachelor of Technology Forensic Investigations from UNISA from 2003. Ms. Nkabinde had a national diploma from the Vaal Triangle Technikon in 1998. She had a Bachelor of Technology in Industrial Engineering at Pretoria Technikon 2002. She had a Bachelor of Science and Honours in Applied Science at the University of Pretoria in 2004, and she had a Master of Science Engineering Management from the University of Pretoria. The CCMA held that Ms. Nkabinde had to be successful with her unfair promotion claim for two reasons. The one was that she was acting in this position, and that she was referred to, secondly, by the title of this role, being Senior Business Enablement Manager. That, in the view of the Commissioner, created a reasonable or legitimate expectation for Ms. Nkabinde to be appointed to this role. And it ordered the payment of 9 months' salary, which is just short of R1 million. Eskom was obviously not very happy with this result, and it took the matter to review before the Labour Court. The Labour Court said the following: if there ever was a hopeless claim for an unfair labour practice claim, this must be it. The court said, firstly, sorry, I'm just getting to the correct page here. The onus is on the employee to prove that there was a decision that was unfair. In considering whether this happened, the employer took into account Ms. Nkabinde's experience, her qualifications, and it found that she was superior to Ms. Nkabinde. It is not sufficient for an applicant in an unfair labour practice claim to just show that I have experience and I have the qualifications to perform this role. There needs to be something unfair in the employer's assessment and appointment decision of the successful candidate before you can be successful with your claim. So it's actually quite a high hurdle to get over, because what the applicant needed to do is to show that the appointment of someone else was unfair. As regards the legitimate expectation, does it create a legitimate expectation if you are acting in a position? No. Does it create a legitimate expectation because you are referred to by the title of that role? No. The court said acting in a position and being referred to by that title is not sufficient. A legitimate expectation can only be created if there are express promises or if there is a regular practice by the employer to actually appoint the acting person. There was no evidence to this effect in respect of Ms. Nkabinde. Then, importantly, the court said recruitment and appointments are exclusive preserves of the employer. When an employer appoints one of its employees to act either in a vacant position or in another employee's stead, there is no automatic obligation for permanent employment. I think that is important, and it is giving comfort to employers that merely appointing people in acting positions is not enough to create an entitlement to that role. Of course, it is important that you say in the letter appointing that individual to act that this is an acting position, that it is temporary, and in practice, not to make promises of appointment to that role. Thanks, Lou.
Thank you, Talita. Again, important principles. Our last case for today, dealing with the issue of settlement agreements. Melissa will be taking us through the case. Thanks, Melissa.
Thanks, Lusanda. So I'm going to be dealing with Naidu versus iCollege, Pty Limited. It's a Labour Court decision from last month, and it dealt with an application to make a settlement agreement an order of court. And in this particular instance, the court declined to make the settlement agreement an order of court. So in that case, the employee was suspended and was facing disciplinary charges. And in order to avoid the dismissal, she then approached her employer and requested a mutual separation agreement, which the employer agreed to. But the parties then structured the agreement as a dismissal due to operational requirements. Then there was a dispute of fact on the terms of the settlement agreement. And in terms of that agreement, there was supposed to be 4 tranche payments to be made to the employee as a settlement payment. And in return, she was required to return all of the company property. And there was a dispute as to whether she had in fact returned all of the company property or whether she had saved it onto a personal hard drive of hers. And as a result, the company then refused to continue paying the tranche payments to her. And then she approached the Labour Court to request that the settlement agreement be made an order of court. And there the court said that the very purpose of making a settlement agreement an order of court is so that it can be enforced. But there are instances where it may be an appropriate exercise of discretion of the court against making it an order of court. And one example is if there's a dispute as to the validity agreement. Another example is if there's a material dispute of fact. And if there is a material dispute of fact, this would then lead to more issues and contempt of court proceedings if they were to make it an order of court. And the court looked at the requirements that has to be established if you are approaching the court to make a settlement agreement an order of court. And it said, firstly, it must be in writing. Secondly, it has to be a settlement of a dispute. So the genesis of the agreement needs to be a dispute or something that could be referred to arbitration. For example, an unfair dismissal. It also must be a dispute that one has a right to refer to arbitration or to the Labour Court. And it must not be a dispute where arbitration is the only way in which it can be dealt with. So, for example, an organizational rights dispute or disputes relating to essential services. And in this case, there was no dispute. Here, the court found that the mutual separation agreement was nothing more than a resignation on agreed terms. And in reality, even though the parties had described it as a termination for operational requirements, this was clearly a farce because the only reason they put that down in the settlement agreement was for the employee to benefit from the tax break applicable to retrenchments. So there was no dismissal. It was simply a resignation. And in that case, the court declined to make the settlement agreement an order of court. Thanks, Lou.
Thanks, Melissa. That brings us to the end of today's employment law update. Thank you very much, everyone, for joining us this morning. Please look out for the recording of this webinar and also for the case summaries that will be provided to you. We'll see you next time. For those of you taking an end of your break, hope you have a good one. Goodbye.